In UK, the traditional system of unregistered conveyancing had no national record of the ownership of the property other than the deeds themselves. Indeed, early transfer of property were not even required to be made in writing. The system was clearly open to fraud and misuse, as deed documentation could always become lost or damaged. On each purchase, the purchaser had to undertake an investigation of the title deed to prove that the seller had a good root of title, and this had to be repeated on each sale of the property. This problem was soon recognized, and over a period of 300 years, attempts were made to regulate the system of recording land ownership in the UK. The first successful legislation introducing the principle of registered title was passed in 1862. The idea was to have a system of registering title to land which had two features. Firstly, the title to the land would be guaranteed by the states, and secondly, it could be relied on by all prospective purchasers as a proof of ownership for the property. However, such act was later replaced by the Land Registration Act 1925, which also had been repealed by the Land Registration Act 2002. That adopted most of the original principle and ideas from the 1925 Act. The scheme of registration of a title aims to create a system in which one registered will disclose all of the relevant details concerning who owns any piece of land and all the rights and interests that binds that land. Registration allows registered estate in land, both freehold and leasehold, to be separately registered, each having its own title on the register. The aim of registration brings in the concept of once it is entered into the register, it is regarded as conclusive. The key feature of the land registration scheme is that when an application is made to enter a title on the register, the title is investigated by the land registry staff and it will not be entered on the register until they are satisfied that it has no defects. The Land Registration Act 1925 intended to introduce a system of land registration which would eventually extend it to all land. The aim was for the system to extend to all areas within 30 years, which has been proved to be overly optimistic. Under this act, there are two ways of registration, which is voluntary registration and compulsory registration. In voluntary registration, the owner had the option of whether or not to register the land, while in compulsory registration, the purchaser had to register as soon as an event triggering the registration took place. The Land Registration Act 2002 aimed to achieve the original objective outlined in the Land Registration Act 1925 of converting every title in land to a registered title. However, the land registry themselves admits that there are still millions of unregistered titles in the existence. The objective of the 2002 Act can be discussed into four broad points. Firstly, the Act compels that the register should be a complete and accurate reflection of the state of titles of the land at any given time. Secondly, the Act reduces the number of overriding interests in the land. Thirdly, the Act urges that the law on adverse possession should be reformed. And lastly, the Act itself should reflect the advances in modern technology development. The 2002 Act has extended the types of leasehold estate capable of registration from any lease in excess of 21 years to any lease in excess of 7 years. Any lease which is to take effect more than 3 months after the grant of the lease, known as the future lease, must be registered. Under this provision, a lease of less than 7 years may need to be registered as well. They cannot take effect as overriding interest because they would not be visible to the purchaser when visiting the property, so the purchaser would have no way of knowing that they were actually in existence. There are 3 separate provisions covering registration of the title under the 2002 Act. Under Section 3, which covers the first registration of the title, a title may be voluntarily registered and it is not triggered by some event such as purchase. This does not apply when there is a transfer of title. However, as compared to Section 4, which would be discussed later on, voluntary registration incurs a lower fee as it would be tempting to use a cheaper fee for voluntary registration before a sale has been finalized. Under Section 4, however, which also covers first registration, there is a provision for compulsory registration of title which when an event triggers the need of register. This includes a wide variety of circumstances that stretches from a transfer of sale to a transfer for valuable consideration and a gift, while Section 27 talks about the disposition of an estate or charge which is already registered. So gradually, area of compulsory registration were extended to more and more of England and Wales. However, in the year 2010, over 10% of all titles to land remain unregistered, as inevitably, it still costs more to register a land than to not register it.
The protection of interest that comes along with the registration of land encapsulated in LRA 1925 and LRA 2002 can be challenged through the 3 principles underlying the system of registration brought out by former Chief Land Registrar Theodore Ruoff, which are the mirror principle, curtain principle, and insurance principle. The register is supposed to reflect the correct legal situation and there's no need for further historic investigation beyond the register. and whatever is registered is guaranteed to be the truth for a third party of good faith, and a bona fide possessor who does not appear on the register will be compensated under the insurance principle. And the topic of discussion in this video lies within the mirror principle. Mirror principle states that the registration of title is a mirror that reflects accurately and completely the details of the title of the land. And these details refer to the identity of the owner, the nature of his ownership, any limitations on his ownership, and any rights enjoyed by other persons over the land that are adverse to the owner. The principle makes it possible to investigate the title to the land with absolute minimum of additional inquiries and inspections. The case on point to illustrate this concept is Gray and Gray, which lays down the objective of land registrations, which states that any prospective purchaser of registered land should always be able to verify the exact nature of all interests existing in or over the land which he proposes to buy by simple examination of the register. As we know that it has been the purpose of the LRA 1925 to ensure good title by means of compulsory registration. And prior to this act, purchasers find themselves overwhelmed by masses of title deeds and existing interests over the land. So compulsory registration sought to provide a system that encapsulates the idea that the register should reflect the totality of rights and interests of any land for the benefit of the purchasers and third parties. Thus came to the view the idea of mirror principle. Being one of the central pillars of registration, the concept of having a mirror effect surrounding the land register is to convey a reflective character fully of the land in question, accordingly ensuring that any adverse effects that may reign upon a purchaser or third party are in full disclosure as made certain by the advent of compulsory first registration in 1989. This idea is further enforced in the 2002 Act, which in particular desires to make the register as perfect as a mirror as possible. And under the 2002 Act, mirror principle has been effective in reflecting the full character of land, as any purchaser and any third party will be able to get hold of the information regarding registrable estates, registered charges, and any land interests that are protected by registration. Registrable estates are those capable of existing in law and may be registered in their own right with a unique title number. And nowadays, two legal estates that most accurately reflect the ownership of the land are legal freehold and legal leasehold granted for more than 7 years. Besides, mirror principle operates in a way that the register would have to review any registered charges that derive from the power of registered proprietor to mortgage the land in order to release its capital value. Legal mortgage has to be registered in order to retain its character as a legal interest. Comparing the 1925 and the 2002 Act, the charge certificate, which has been used as the mortgagee's evidence of title, is no longer necessary because the register itself is open for inspection. And another point to note is that under the 2002 Act, unless the property rights amounts to registrable estates or registered charges or overriding interest, it must be entered on the register of title by means of a notice to preserve its effectiveness against the purchaser. Those rights refer to interests protected by registration, which comprise the bulk of third-party rights such as covenants, options to purchase, and many easements. Section 71 of the LRA 2002 stipulates that the applicant for registration of title has the general duty to disclose all the overriding interests so that they are protected by registration. So, in order to make things simple, through mirror principle, those proprietary rights registered in the land registry allows owners, purchasers, and third parties to know in advance how to protect their rights and what will happen to those rights if the land over which they have happened to be sold, mortgaged, or transferred.
Theoretically, the idea of the mirror principle is for the register to reflect the totality of rights in an overland to ease and speed alienability. However, the reality is such that there exist certain cracks to this mirror principle which have affected the integrity of this mirror principle. These cracks can be attributed to the existence of a group of interests known as overriding interests. Overriding interests were first addressed in Section 70 of the LRA 1925 as a group of unregistered interests that bind a purchaser without notice or being recorded in the land register. Hence, the introduction of LRA 2002 was aimed at reducing the scope of these overriding interests. It is reasonable to contend that LRA 2002 has been successful in reducing the scope of overriding interests, therefore making the reflection of the mirror principle more accurately. Nonetheless, the scope of these overriding interests have only been limited, not yet been rectified. One noticeable flaw in the 1925 Act is that it has failed to distinguish between the first registration and registration of a disposition. This has been rectified in LRA 2002, whereby Schedule 1 lists the interests which override first registration, and Schedule 3, which lists the interests that override a registered disposition. Although these two provisions are somewhat similar in their scope, it remains true that Schedule 3 is narrower than Schedule 1, as the overriding interests under Schedule 3 are confined to those interests that could be discovered by careful inspection of the land by the transferee or purchaser before the transfer is made. This is aimed at eliminating any undiscoverable overriding interests. The first category of overriding interest is legal leases not exceeding 7 years, and this is provided for under Schedule 3, Paragraph 1 of the LRA 2002. Essentially, this provision simply means that a legal lease originally granted for 7 years or less will override a registered disposition. Legal leases which are longer than this duration will then be registrable as individual titles. Similarly, equitable leases are also excluded from this category of overriding interests. Equitable leases must be protected by an entry of notice on the register or take effect as an overriding interest through the discoverable actual occupation of the tenant. Therefore, under first registration, short-term legal leases will override. However, as for any existing leases, there was an overriding interest within Section 71K of the LRA 1925 before the 2002 Act came into force. Its overriding status will be preserved under Schedule 12, Paragraph 1 of the LRA 2002. The second category of overriding interest is stipulated under Paragraph 2 of both Schedule 1 and 3 of the LRA 2002. This provision is the most important category of overriding interest. Actual occupation is case-centric in nature. Both LRA 1925 and 2002 mention actual occupation, but the phrase has not been statutorily defined. Moreover, there are notable differences between Schedule 3, Paragraph 2 and its sister provision in Schedule 1. This can be seen in the restriction of Schedule 3 in the circumstances in which a person can claim for overriding interest by virtue of their actual occupation. Nonetheless, the guidance provided for under Section 71G of the LRA 1925 will remain relevant. The general principle under Schedule 3, Paragraph 2 is that a person claiming for overriding interest must establish two things. Firstly, that he holds the proprietary interest in the burdened land. Secondly, that he is in actual occupation of the land. Absence from the property for a short period of time does not preclude a person from being considered to be in actual occupation, and actual occupation does not have to be exclusive or continuous, although under the reformulated provision in the LRA 2002, occupation will now have to be discoverable despite the occupier's absence from the property. Moreover, Schedule 3, Paragraph 2 LRA 2002 placed a positive obligation on the purchaser to make a reasonably careful inspection of the land to discover actual occupation. While this will inevitably require the purchaser to make enquiries of the persons present in the property, the policy behind Schedule 3, Paragraph 2 is not to introduce the doctrine of notice to the registered land. However, there are two instances whereby this overriding interest of the person in actual occupation will cease to take effect. This is in a way further strengthens the idea of register as a mirror of all rights in the registered land. In essence, the rights of a person in actual occupation will not override where either enquiries have been made of the right holder and they have failed to disclose the rights in the circumstances where he could reasonably be expected to disclose it, or the rights holder actual occupation is not obvious on a reasonable inspection of the land and the person potentially bound did not have actual knowledge of the interest at the time of disposition. In the case of Boland, the House of Lords held that Mrs. Boland's constructive trust interest was an overriding interest by virtue of Section 71G. Hence, it can be said that there is a balance between the informally created interests of the claimants who cannot reasonably be expected to protect themselves and the protection of purchasers who have taken reasonable steps to discover new interests.
I'll be explaining on the third category of overriding interest, which is legal easements. The first point to note is that any easement qualified as an overriding interest prior to the entry into force of the LRA 2002 will continue to override irrespective of the provision of LRA 2002. Secondly, only certain types of legal easements and profits may override. any other easements and profits that fall outside of this provision require protection by an entry in the register. Moreover, legal easements and profits expressly granted or reserved on or after 13 October 2002 out of a registered title is also excluded from this category of overriding interest, as it amounts to a registrable disposition under Section 27(2)(g) of LRA 2002 and is required to be registered. Therefore, to operate as legal easements, all easements are required to be registered. This in turn means that only new legal easements which are capable as being overriding are those which are impliedly granted or expressly granted. Moreover, in addition to being either expressly created or impliedly created, legal easements will only override a registered disposition under Schedule 3 if any one of the following requirements has been satisfied. Firstly, the easement is registered under the Commons Registration Act 1965. Secondly, the easement is actually known of by the purchaser. Thirdly, it is obvious on a reasonably careful inspection of the land. And lastly, it has been exercised within 1 year prior to the relevant disposition. As for equitable easements, it is clear that equitable easements and profits are not operational under this provision, and therefore only legal easements and profits are recognized under the scheme. Besides legal easements, actual occupation, and short leases, there also exists a class of permanent overriding interests under para 4 to 9 of Schedule 1 and 3, such as customary rights, public rights, local land charges, and mines and minerals. However, despite the existence of this overriding interest, which has rendered the mirror principle inaccurate, the mirror principle can be seen to be further strengthened by the principle of overreaching. This principle of overreaching is a process whereby the equitable rights, which would otherwise be binding against a purchaser, can be transferred to a portion of the purchase price of the land, therefore sweeping away the particular equitable right. When this occurs, the equitable rights are said to have been overreached and will no longer bind the purchaser, even though those equitable rights fall under the category of overriding interest. In essence, overreaching is a purchaser's trump card. There are two essential conditions that must be met before overreaching can occur. The first condition is that the equitable right must be the kind that is capable of being overreached. Overreachable equitable rights are defined in Section 2 of the LPA 1925. In essence, in order for the equitable rights to be capable of being overreached, the equitable rights must exist behind a trust of a land which is co-owned and which have a readily identifiable monetary value, as concluded by Lord Denning in the House of Lords case of City and London Building Society against Flag. However, equitable interests such as equitable easements and equitable lease can never be overreached and will bind the purchaser of the registered land according to the rules of registered land. The second condition that the statutory requirements for overreaching must be satisfied is that the sale must be made by those persons in four circumstances in order to constitute as an overreaching transaction. Section 2(1) of the LPA 1925 tells us that for overreaching to happen, the transaction must be made by at least two trustees or a trust corporation exercising valid powers under a trust of land. The rationale behind this is to release the purchaser from binding rights by allowing the equitable owners to take a share of money in compensation for their loss of rights. The second circumstance is in which overreaching can occur is when transaction is made under the provisions of the Settled Land 1925 Act relating to the operation of strict settlements. The most common examples of strict settlement occurs where a landowner provides in his will that the land is to go to his eldest son for life and that the remainder is to be passed to his son's eldest son in fee tail. In this sense, the eldest son or other trustees have the power to sell the land to others without being bound by the interests of their sons. It is said to be an overreaching transaction, as the interests of the eldest son's son are swept off into the proceeds of the sale. Overreaching is also possible if transaction is made by the mortgagee or personal representative in exercise of their paramount power to deal with the land which prevails over the interest of any co-owners. The court may also order for an overreaching transaction for the benefit of the purchaser and transferee under Section 14 of the Trust of Land and Appointment of Trustees Act 1996.
From all of the points that has been presented above, land law in England and Wales operates on a torrent system, whereby there are three fundamental principles that governs the area of land registration. Though the reform to land registration was established, however, there are still many underlying problems with the concept of land registration in England and Wales. The object of land registration is to provide a method of creating and transferring interest in land which is simple, speedy, and cheap. The cliché, however, that the transfer of land should be as simple as the transfer of stocks and shares is often used, but is not that simple due to several factors. mainly overriding interests, which in their nature are not registered but binding on the land. To this end, the land registry examines the title of the owner of unregistered land, usually following the first purchase of the land after registration of title in that area becomes compulsory, and create a register of the proprietor's title. This register defines the property and the estate owned by the proprietor and then specify all the interests to which a transfer of registered estate would be subjected to. Any purchaser for value from the registered proprietor gets exactly what is contained on the register, the title to the goods, and defects and limitations, if there are any, are open for inspection on a state-guaranteed document. If there are any interests which affect the state but which are not noted on the register, then these may be ignored and defeated by the transaction, which operates from a curtain principle that owners do not have to concern themselves with what exists behind a registered title. The owner of such minor interest must ensure that it is noted on the register if it is to be effective. However, this simple pattern is broken by the existence and the class of rights and liabilities known as overriding interests, which binds the land whether they are noted on the register or not. The Land Commission saw the existence of overriding interest as a major obstacle to this reform, but the desire for the register to be a complete and accurate reflection did not lead to overriding interest being abolished altogether. Instead, they have been significantly reduced and with more to be phased out over time. In the case of Strand Securities and Caswell, Lord Denning has classified overriding interest as a category that is so important that it is capable of undermining the mirror principle, which the whole land registration system is based upon. To sum up our discussion, it is important to note that Parliament has created the e-conveyancing system. Electronic conveyancing, also known as e-conveyancing, is a more efficient, accurate, and secure way of conducting the settlement and lodgement stages of a conveyancing transaction. It replaces many of the paper and manual processes traditionally involved in property transactions. It provides a reduced risk of manual errors, fraud, and delayed settlement, and it closes the gap between the moment of disposition and the moment of registration, thereby having less risk because the interest title is registered immediately on settlement. However, Section 93 of the Land Registration Act 2002 has yet to be implemented, though it has already been included in the legislation itself. Furthermore, the reduction or complete elimination of overriding interest has been suggested by a few scholars, which will completely wipe away the need for purchaser to conduct reasonable inspection of the land to find out if there are any unregistered interests that he or she will be bound by. The purpose of LRA 2002 was to reduce and also purpose to eliminate the amount of overriding interests that can still belong in that category. But there are still a few of them left, and the Parliament should enact a new legislation that would underline and identify these remnants and implement a compulsory registration upon all these rights. Though it is unreasonable to create a separate title for all these rights, but the implementation of e-conveyancing would undoubtedly facilitate the total elimination of these rights. Bringing in an example of a foreign jurisdiction but close to home, under Italian laws, once the deed is registered, it is binding upon all third parties, which means that the concept of overriding interest, which a third party could acquire rights over your property without you realizing as a purchaser, is non-existent under Italian law and is also listed down in legislation.